20
So
total?
now you get, no, those two get 20 and 15 with firefighters.
Okay, thanks, sir.
Okay.
Thank you. Yeah, you did. Yeah. Yeah. Mm-hmm. Yeah. 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 Okay. Yeah. I'm glad we really did that. Oh, Eric. He was a year ahead. Yeah, he was a year ahead. He was a year ahead of me. Step one.
Hey everyone, just a reminder, mute or turn off your electronic devices. Please be seated. We have two cases on the docket that we've combined into one argument. And I believe my lawyer said we'd like the City of Houston and the association to split the first 15 minutes. And then 15 minutes for the plaintiffs, as I call them, and then a 5-minute rebuttal. All right. Who's going to go first between the City of Houston and the association?
Judge, I will.
Okay.
And as I said, so it's 20 minutes total
for your side.
For our side.
Yes, and I was just giving you 5 minutes for rebuttal, but if you would prefer to take longer on direct, that's fine too.
It's going to be 7.5 for me, and then Ms. Marvel 7.5, and then rebuttal.
Okay.
Okay.
Thank you.
Thank you. May it please court. Joseph Collier for the City of Houston, appellate. Also Rick Navarro for the City of Houston. He'll have the rebuttal. As you know, we are here because the trial court did not grant our plea to the jurisdiction and dismiss the matter. The current, as the facts stand, this case started back in 2017. We finally got it settled in March 21st of 2024. It went up to the Supreme Court, came back down here. I think it had a little trip here in the 14th Court of Appeals for a while on part of it. But the Supreme Court sent it back for the District Court to resolve the compensation issue. With that in mind, the city and the association got together, they negotiated, they reached a settlement, and that's sort of where we are. As part of the settlement, the City of Houston agreed with the association to pay X number of dollars. The association made determinations about how they would distribute X number of dollars. The assistant chiefs have filed an intervention. Their intervention was filed 4 days after the final judgment was signed. They believe that they could take the benefit of the 174.08 waiver of immunity to bring their lawsuit. I read interveners as folks that have to have the right to bring something individually. It's our position they can't do that. They gave up that right when they decided to have an association which they all voted for to be their exclusive bargaining agent.
Except that the agreed judgment says that the association does not bargain on behalf of the assistant chiefs.
Well, in that part of the judgment, the assistant chiefs, the management part of it, and that's what they are. There's a city ordinance, 3454, that talks about assistant chiefs being part of management. Why the association did not, actually, Judge, they bargained for them when they were firefighters. When they occupied the role of a firefighter, the association bargained for them.
Well, but they're firefighters under the statute. The assistant chiefs are firefighters under the definition in the statute.
Well, correct. 174.003 certainly says firefighters, assistant chiefs being that.
Right.
That's true. However, for whatever reason, a decision was made with the association to not do that. And an agreement was entered into. Our position that 174.109 makes that a binding agreement. And the agreement consisted of 174.022, then that means that the city has qualified for the prevailing wage rate under 174.021. So by that agreement, we have discharged our obligations to provide prevailing wages for the firefighters. And what we have here is, from the city's perspective.
But you agreed that the settlement didn't cover them.
Well,
I mean, that's what's in the judgment.
The judgment states what it states. That's correct. Judgment states what it states. However, the question would be, would those assistant chiefs have the ability under 174 to have an immunity waiver to bring something in their own, individual capacities? It's the city's position that they would not have that. that there's no waiver for that. That they're essentially talking about a contract and benefits accorded under a contract. As the court knows, the Tort Claims Act, municipalities do not have, there's no waiver of immunity under a contract. So we look at all those issues from our perspective. And for the city, we believe that we shouldn't be here. That under,
But you're the one that agreed to cut them out.
well, I wish I wasn't part of those negotiations, Judge, so I don't know what the agreement was and
Well,
how
I
they
mean,
got there.
according to
Well, I
the
mean, we know what
judgment-
the agreement was. They were excluded.
That's correct, Judge. That's correct. The question becomes, how do they, can they get that relief in their individual capacities under 174? I think when they have an association representing them, I don't think they have an individual claim. I think all those subsumed when they agree to have an exclusive bargaining agent.
So you think their only remedy is against the association?
Yes, I do. Yes, I do. Part of what exists under there is, our position is that 109 of 174 kind of binds all the parties, that agreement. And so there are no other claims they can make against the city based on that we have eliminated any cause of action against the city, that we complied with all the provisions of 174. And consistent with, I believe it's,
Well, the original lawsuit was on behalf of the firefighters, which by statutory definition includes the assistant chiefs,
correct.
and that part wasn't settled under the terms of the agreed judgment.
Well, the association represents all the firefighters. Now, if the association,
But the agreed judgment said they didn't. So it seems like their claim is still outstanding, whether they have to get the union to negotiate against you on their behalf, or whether they can now go directly against you, one or the other.
I don't think that individual assistant chiefs can go against the city once there is an exclusive bargaining agent. Even though exclusive bargaining agent, at least according to the judgment says, we didn't negotiate for them. We think that once that 101.051 part, exclusive bargaining agent exists, and that's where we are.
Since the assistant chiefs were carved out of the settlement, could the association come back and negotiate on behalf of the assistant chiefs a wage rate?
Judge, I believe that not under the current configuration of 174, 109. I think that binds up everything.
But the assistant chiefs were severed out of the lawsuit. They were excluded from the settlement. So why couldn't the association come back and negotiate for the 12 assistant chiefs?
Well, maybe that's an option. I don't know if that's a viable option when one looks at 174, 109. Because I think that agreement that was reached, however it consists of, eliminates the city's obligation at that point in time.
Okay, thank you.
Thank you.
May it please the court, opposing counsel, I'm Vincent Marable with Troy Blakeney on behalf of the association. I'm going to try to answer and talk about some of the questions that the panel asked during the first portion of the argument. Justice Christopher, you asked a question about the association not bargaining for the assistant chiefs. That is true. And in the context of this lawsuit, the collective bargaining agreement expired before the lawsuit was filed, and there was no collective bargaining agreement, another collective bargaining agreement, until after the settlement. And so in that context...
So then you had no authority to bargain on behalf of anyone?
Well, this doesn't involve collective bargaining. And in that regard, let me answer your question and address some of the questions you were asked in terms of the way that 174 is structured. The voters of City of Houston vote, and they decide whether or not they're going to allow the police and the firefighters to collectively bargain. The firefighters have had a union for 100 years. So the city says, okay, you can collectively bargain, and the City of Houston and the firefighters sit down and come up with a CBA. The pertinent provisions of 174, which is the statute which deals with collective bargaining, there is a subchapter B, which deals with the requirement that the City of Houston pay the firefighters private sector labor standards compensation. Once the City of Houston and the firefighters enter into a CBA, they are deemed to, the City of Houston is deemed to have satisfied that private sector labor compensation standard, and that's what happened. And so at a point in time, there's a negotiations going on for a new CBA, impasse, they fail. This is while Mayor Turner is involved, and at that point in time, the CBA expires, there's no CBA, and so the association files suit. And that comes to what's in the briefing is the 174.252, which gives the association, and only the association, the right to sue the City of Houston for not complying with the private sector labor standards. And that lawsuit gets filed in 2018 after there's no longer a collective bargaining agreement. For the entirety of that lawsuit, there is no collective bargaining agreement the entire time. The issue of the assistant chiefs and collective bargaining and those issues come to fruition once the settlement amount is agreed to between the City of Houston and the union, and it starts to document on the $650 million, and no agreement can be reached for the period of time that the 13 assistant chiefs are working in the assistant chief level. Because the assistant chiefs that did not become an assistant chiefs until sometime during the period of time, during the 7-year period, they received settlement payments. The period that they did not.
As a firefighter, but not as an assistant chief.
True. And Justice Wilson, the reasoning that the assistant chiefs did not receive overtime is, we've given you a case out of the 14th Court of Appeals that says they don't get overtime, and there was pushback. We could not reach an agreement with the City of Houston for the assistant chiefs to get overtime for the period of time that they were assistant chiefs because of the command staff level that they served.
Yeah, but there's nothing to preclude you from negotiating a pay increase and documenting it as a pay increase rather than overtime.
And it has to be done with the City of Houston's approval. And so
there's nothing to preclude you from negotiating for a pay increase.
To negotiate it, we can negotiate and negotiate any type of agreement, because the way that the 174 works, you can negotiate whatever agreement you want to, and once you have it negotiated, you're in compliance with the statute. And what happened in this case was there were numerous efforts over the years to negotiate. John Whitmire comes in as the mayor, and the number gets agreed on, and then it starts to get documented, and there's no agreement reached for payment on the assistant chiefs for that period of time that they're serving in that level. So we're faced with a situation. Are we going to settle this case on behalf of the 4,000 for this period? Or are we going to go to trial because we can't reach an agreement as to this period of time for the assistant chiefs? And that's where we were left as the association. You ask a number of questions. You say that the claims of the assistant chiefs have not been settled. They have been settled. Those claims were asserted in the lawsuit, and we settled it, and we have a final judgment dismissing those claims, and that's what the final judgment and settlement say. They don't get paid for a certain period of time, but they were not carved out. Those claims were not preserved. When they tried to get mandamus relief from this court to preclude the settlement, they asked for emergency relief. Judge Reeder would not give them a temporary injunction. We had a temporary injunction hearing with an assigned judge in the trial court. This court would not give them temporary relief. So what they decided to do was to go forward on a claim that says, hey, City of Houston, you violated 174 as to us, you need to pay us, and union, association, you didn't fairly represent us, which gets into my mandamus. Because the case law says that claim is inextricably interdependent, meaning that if one of them fails, they both fail, and they do not have an argument as to why they can assert the same claims that we sued on and the association settled when they're not the association, because the statutory provision says very clearly that only the association can assert that, and if that's the case.
Well, their argument is that you breached the duty of fair representation by not asserting claims on their behalf.
Assume that that's the case. Assume for purposes of this mandamus that we breached the duty of fair representation. I say we didn't, but let's assume that. They have got to prove that they have a cause of action that they can sue the City of Houston on for the 174-252 violations, and only the association can assert that. They cannot assert that claim individually.
Well, they're saying that you should have asserted it on their behalf.
That's correct.
Well, why isn't that a viable claim?
Because that's
if
not
you had asserted it on their behalf, you could have sued the city.
We would have had to have tried the entire case for everybody, not just the
Well, but
assistant.
that is your defense to the breach of duty of fair representation, and we're not here on that.
We're not on-
We are only at a jurisdictional stage.
We're not here on the merits of
Right.
of that claim.
Right.
We're here on whether or not they can assert the part of the claim which is inextricably interdependent, which is their claim against the City of Houston saying you violated the statute. They can't assert that claim.
But that's based on your contention that they settled in this agreed judgment, even
Whether
though
we-
the judgment says we didn't bargain on their behalf.
Assume for purposes of this mandamus, and I'm over my time, but I want to answer your question. Assume for purposes of the mandamus that they haven't settled and we didn't assert their claim. The statutory provision says it has to be asserted on behalf of the association. So the fact that we did all those bad things and y'all called it a carve out, however you want to describe it, they still cannot overcome the fundamental standing problem that the statute says the claim has to be asserted by the association. They've given you no case.
Well, that's
no-
the City of Houston's argument. That's not your argument.
Yes, and the reason that.
I don't understand why you think you can piggyback into the City of Houston's argument.
Because the claims are inextricably interdependent. And so if
They've
there's
been
no.
severed. And you agreed to it.
No, the
In fact,
claims.
you move for the severance.
The claims that are severed are the claims that remain in the trial court. Those two claims that are in the trial court, the claim against the city, the claim against me, are inextricably interdependent. And so if the City of Houston's claim that they're trying to assert against them, if it fails for lack of jurisdiction because of lack of standing, then the claim against us for the duty of fair representation is barred and falls as well. So that's why I'm here in asserting a claim that is basically based on the standing because of the nature of the interdependence of the claims. I'm way over my time.
Well, what's the answer to my question that I asked Mr. Collier, which is there anything to preclude since the assistant chiefs were not included in the settlement, is there anything to preclude the association from now negotiating an agreement on behalf of the 12 assistant chiefs?
There's nothing which precludes the association from engaging in any type of negotiation. There's no mechanism to force the association to conduct those negotiations. And the association is not going to do that because their position is they have settled and there's no more money. But if you're asking me, can you sit down and negotiate or try to settle anything at any time? Of course. But there is no mechanism for a court or for the union to be compelled to go and engage in those negotiations.
Where is it in the agreement that you contend that you've settled on behalf of the assistant chiefs?
Because the agreed judgment says that it is a settlement of the litigation that we filed, and that claim was filed on behalf of all 4,000 firefighters. And they'd be included as part of that claim. That's a distinct issue from whether they're part of the collective bargaining unit. They're part of the firefighters, we sued, we settled the claim, the association has the right to do that.
Thank you.
May it please the court. Oh, sorry. Josh Furry for the Assistant Chiefs. The act is clear, Your Honors, that the Assistant Chiefs are firefighters. And the litigation, the underlying suit that was pending since 2017, was brought on behalf of all of the City of Houston firefighters, including the Assistant Chiefs. For years, they understood that they were part of that litigation. It was only at the moment last spring that they learned that a tentative settlement agreement was being negotiated that expressly excluded them, that they filed their petition intervention in the underlying case. I do want to correct for the record, it was filed prior to entry of the final judgment in the case. So the intervention was even heard by the court before the final judgment was signed. The reason why the Assistant Chiefs intervened in the underlying case is because the Act, Chapter 174, is their sole remedy for for ensuring that they are paid according to state law. State law ensures that they get paid comparable to the private sector employment. And one important thing that I want to point out about Chapter 174 is that in the beginning of the actual statute, the purpose is stated. And there's actually two important prongs here. The first and primary purpose of the statute is to ensure that firefighters are paid comparably to private sector. The second prong goes into their rights to organize, their rights to unionize. That law allows them, it provides them the right, but not the obligation to form a union. In this case, of course, a union was formed and the city adopted the law back in, I think, 2003. They are the Assistant Chiefs are dues paying members of the union. And while the underlying litigation was going on, they were part of it. This is not, as the appellants have argued, a new lawsuit. This is not an example of kind of a rogue batch of employees attempting to collectively bargain on their own. In fact, I think we heard some argument from the other side acknowledging that this is not collective bargaining that we're talking about. So to the extent they argue that the union is the sole bargaining agent, I would agree that when it comes to collective bargaining, that's correct. However, this lawsuit isn't about collective bargaining. It isn't about coming up with a new contract. It's about ensuring that the City of Houston firefighters are paid in accordance with the law.
But you have agreed that they are your representative, the union,
The Assistant Chiefs.
in such a lawsuit.
Yes, Your Honor, that's correct.
Okay, so if the union chose not to assert your claim, you have a claim against the union, but how do you have a claim against the city?
Because the Assistant Chiefs were part of the litigation, the underlying litigation, that took a trip up through the Court of Appeals and ultimately to the Texas Supreme Court. The Texas Supreme Court looked at it and said, you know what? There is a waiver of sovereign immunity here because of the fact that they had gone through the arbitration process, etc. So determination was already made as to the sovereign immunity defense.
Well, as to the 4,000 in general.
Correct, which includes the Assistant Chiefs, Your Honor. So when we talk about this appeal, which really at its core is the City of Houston's appeal of a denial of applicable jurisdiction, our primary argument here is that the question of jurisdiction was already determined. In the underlying case of which the Assistant Chiefs were parties because they are in that group of firefighters. But I do want to also kind of point out in our briefing that we believe that in addition to that Texas Supreme Court finding of jurisdiction, there's also independent statutory language that confers jurisdiction. That goes to the express sovereign immunity waiver in the statute in Chapter 174, and also the party aggrieved language, which doesn't say that only an association can bring a lawsuit under the chapter. So where we stand is You know, I
Well,
think.
enforcement generally says a party aggrieved by an act or omission can sue.
Yes, Your Honor.
But you agreed that the union would be your representative in these lawsuits,
The assistant chiefs.
not individual.
That is correct as to collective bargaining, and so that is that exclusive bargaining agent language that's in the statute. Remember, the statute really kind of has two main purposes. It codifies the right to organize. The trade-off there is, look, you can form a union, but you can't strike unless these conditions are met. But the primary purpose, and that's 174.002A, the policy, is to cover this compensation question, to ensure that firefighters are paid fairly and paid comparable to private sector employment. Those are two separate and distinct purposes behind the statute. And so I think there's been a little bit of muddling by the other side, kind of saying, well, look, you know, they can't assert any claim because we're the sole bargaining agent. I think that argument is probably correct as it applies to a collective bargaining agreement. They can't splinter off and say, you know what, we want to, as assistant chiefs, we want to negotiate our own labor contract. They can't do that. But that's not what this case is about. This case is about separate pay litigation. And unfortunately, for reasons unknown at this time, because there's been no discovery, the city and the union decided that they would expressly carve out these 13 assistant chiefs who are kind of undeniably firefighters under the code. We have touched on this in our briefing, that we suspect the reason for this is, you know, by calling the payment, the $650 million payment, a payment of back overtime, I have referred to it as an accounting trick. I think what that does is that allows the city to avoid making a pension obligation payment, because state law says, you know, look, with regard to pension contributions by a municipality, we're going to let you exclude overtime payments. So it made the process a little easier from an accounting perspective. But the problem with that, at least with respect to the appellant's argument, is that there is no law that says that assistant chiefs cannot be paid overtime. In fact, we have in the record proof that they were, some of them, were paid overtime. And the Fair Labor Standards Act, which governs the payment of overtime, doesn't say when you can't pay overtime, it says when you must pay overtime. So just to the point, just to touch on that argument of, I think, primarily the union, we're not claiming that they're owed overtime. We're saying that their choice to call the back pay overtime is part of the problem in this case, which is that they are entitled to receive this back pay under the Act. They were part of the lawsuit since its inception, and only at the very end was there this act by the city and the union that carved them out, leaving them with no other alternative but to intervene in the underlying suit and assert their claims. I do want to point out one additional thing while I've got some time, which is the assistant chiefs are not advocating for an opinion that Chapter 174 always allows any employee to bring a claim. And that touches a little bit on that exclusive bargaining agent. We are not advancing the argument that, look, when it comes to collective bargaining, an individual firefighter can bring a lawsuit. That's not what we're arguing here. We're saying that they were already part of the lawsuit, and it was their exclusion kind of at the end that gave right to their standing, their right to intervene, and the question of jurisdiction, sovereign immunity has already been resolved in favor of keeping them in. So the trial court did not err in denying the city's plea with jurisdiction.
Thank you. Are you getting all 5 minutes, or are you splitting your time?
Mr. Navarro's taking all 5 minutes unless he wants me to come answer a question, but he's got the
I think they told me I could have the full
All righty,
5 minutes.
thank
So,
you.
Ricardo J. Navarro for the City of Houston, Your Honors. And I would like to focus strictly on the language of the statute. Now, I have 25 years of bargaining experience in the state of Texas, not only for the City of Houston, but for cities as you know, much smaller than that are bargaining cities. And we work a lot with the statute. The waiver of immunity in the statute is a waiver under 008 which relates, it's vis-a-vis the exclusive bargaining agent. That's another central pillar of the statute, is that the employer is required to bargain with only a single bargaining agent. There's no obligation to bargain with more than one. It has a provision for resolving disputes when you have more than one.
Excuse me, just a
Yes,
minute.
ma'am.
Oh, sorry. I've had this cough for 2 weeks now. It's just, I'm not contagious, I promise.
I hope I didn't cause that.
No.
I'm actually suffering from the same thing myself.
We'll try not to hold that coughing fit against you on your tongue.
No, I think we stopped it.
So under 104, there's a provision for questions regarding representation when you have multiple associations asserting a majority bargaining right. And we've been in litigation in that, and there's a procedure, even going to AAA to do that. That was never a question here. There was never a question here that the HPFFA was the exclusive bargaining agent for the firefighters. And so, it just never came up. There was never any need to be concerned about break-off groups or any other groups. This arose at the time of the
But
settlement.
in your settlement, you agreed to a breakout group.
We agreed that the settlement would be done according to the terms that were proposed by the union and in an amount that the city was willing to pay. And I would point out, as I did to the district court, Your Honor, that in the negotiation process of settling the lawsuit, in a lot of ways it was exactly the same as what happens at the bargaining table. When the union is at the bargaining table and they're representing, however many ranks, they're not all getting the same amount, okay? Both sides are counting votes, trying to get a deal. The union has to get enough votes to ratify the deal with their membership. The city has to get enough votes to ratify the deal by its council, but also has to worry about the firefighters or the police officers voting for the deal. So there's a tendency that the upper ranks will always get less than the lower ranks, because the votes are always at the lower ranks. That's just the dynamic of bargaining. And so here, this is what happened. The union basically came up with a formula that depended on an overtime calculation that is under the civil service statute that is peculiar to Houston, I might add. And they came up with a formula that yielded a number that administration under Mayor Whitmire was willing to live with. And so, yeah, there were some decisions that were made about who would get what. They're not all the same. I think the district court, when we were on the verge of trying this case, and this was pointed out to the judge, basically saying, Judge, even if we go with the experts, their labor experts, our labor experts, you're going to get very different numbers. And not just across the board. You're going to get very different numbers at each rank. Because even their own expert is going to say, this rank's already at the statutory requirement. This lower rank may not be. And so that's why these cases tend to be resolved by negotiation. Negotiation is the premise of this. Now, the waiver of immunity on the judicial enforcement under 252 is a waiver vis-a-vis the association, not anybody else. So when the city closed this deal through an agreed judgment, that resolved the issue, because the statute itself says once you get an agreement, there's a presumption that the parties have satisfied the minimum requirements of 021. Okay? So this is not council is trying to make it seem like everybody is entitled to something. That's not true in the bargaining process, and that's not true in the resolution of the lawsuit. So, there's no waiver of immunity as to the city. When that judgment got signed and the judicial enforcement action got closed, the waiver as to the union ended. And as to anybody else who is not a majority bargaining agent, there's a DARS immunity. That's why we don't belong here. Now, if these, if the interveners have a remedy, it's against the union for bad faith. We have no position on that. Our position is that's a merits issue that needs to be, I mean, there's not a lot of case law on it in state court under this statute, but that's, if they have a remedy, that's where it is, because those decisions were made. From the city's perspective, we just got finally to a point where we had a deal that was palatable, it was affordable, and we were able to close 8 years of open litigation and resolve this case. So we just feel that, you know, there's finality, ought to be finality for the city based on immunity and on a proper reading of the statutory language. Thank you very much.
All right, thank you for your arguments in the case. I apologize for my coughing. We are excused.
No.